Hi, Shell Point. I'm Jeff Corey from the Legacy Foundation, joined by Craig Hirsch from the Shepherd Law Firm, and we're going to talk a little bit about estate planning. Craig, thanks for being here with us today.
Thanks, Jeff. Thanks for having me.
Great. I'm going to ask you 5 questions that I hear most from Shell Point residents, and you're our estate planning expert here. Worked here with residents for many years in their estate planning, so appreciate your being here today.
Well, thank you.
Okay, so the first question is, I have a revocable living trust that I established years ago. I hear that the tax, I don't have a taxable estate anymore.
Yeah, it's $11 million exemption
$11 million exemption. Do I still?
Everybody here at Shell Point doesn't have $11 million?
Not everyone.
Not everyone.
There's several
okay.
that don't.
All right.
Do I still need my revocable living trust?
Well, yeah, you know, estate tax planning is just one element of a revocable living trust planning. There's a few real big benefits that you don't want to give up.
Okay.
One would be probate avoidance, of course. The assets that are funded into my trust, the assets titled my trust. So if I had a trust, it'd be Craig Hirsch trustee for the Craig Hirsch trust dated whatever. If I died, the assets don't go through probate. If I become disabled, my wife Patty is my successor trustee. Patty can step in and serve very, very easily. So that's one benefit.
Okay.
Another important benefit is privacy. You know, in today's age of identity theft, and you know, probate is a public process. So, you know, unscrupulous people might have access to what our assets are, who our beneficiaries are. They're vulnerable at a time when we passed away. Trust assets, on the other hand, never see a court. They're not public knowledge unless there's a controversy over the trust, which is really rare.
Okay. Okay, a follow-up question to that. If I do just have a will, and I'm passing my assets and my estate going through probate, can you tell us a little bit about the process? How long does that take? How long will my beneficiaries have to wait before they see their funds? Well,
that depends, and you know my joke, lawyers sell more Depends than CVS and Walgreens combined. But in any event, it depends really. If I have a small estate, one that's worth less than, let's say, $75,000, I can do what's called a summary administration. Very, very simple, very easy. Doesn't take much time at all. A full probate administration is a process under which your will is appointed, or is accepted by the court as your last will. And if there's any codicils to will, those are accepted. Your personal representative, your executor is appointed. Inventories are filed, creditors are cleared. That takes 90 days to clear the creditors. And then finally, an accounting might be filed, and then distributions are made. It's usually around a 9-month process, 9 to 12 months in most cases.
Okay.
In more complicated cases or controversial cases, might take longer.
Okay, great. Second question, what is the best way to pass on IRAs and retirement plans?
Well, yeah, that's a loaded question, isn't it?
Yeah, it is. I mean, we've worked years, you know, for these assets to grow without any taxes, and then all of a sudden, our beneficiaries are going to get really whacked. So, how do you? Is there some best way to pass on your? Well,
you know, in fact, I'm writing a book on that. Hopefully, that'll be out in the next year or so. The issue with IRAs is the complicated rules about their minimum required distributions. We all know that you and I don't, as the account owner, we don't have a minimum distribution until we're 70 and a half, right?
Right.
And when we die, if we have a spouse and our spouse rolls it over, it becomes their IRA, and 70 and a half is the magical date for them. But what happens when we leave it to our children or grandchildren even? You never want to leave an IRA directly to a grandchild who is a minor, because then we have to have a court-appointed guardianship with accountings and all in order for them to withdraw, because a custodian can't make a distribution to a minor. Okay.
Okay.
Secondly, if we have children and we want to leave those amounts to children or other loved ones, nieces, nephews, cousins, whoever, they have minimum distributions the year following our death, even if they're not 70 and a half. Now, what we want to do typically is protect those distributions and stretch them out over the lifetime of that beneficiary, which we can by naming them directly. But if we want to protect those assets, we want to put it through a trust, which is a special type of trust that must meet 5 federal requirements in order to be stretched out over the lifetime of that beneficiary.
Okay, what kind of trust do you call that?
We call that a retirement plan legacy trust. That's the name that we use in our office. Other offices may call it something different. But you typically don't want to route an IRA through your revocable trust, because those 5 rules I just mentioned are very specific, and a lot of trusts don't satisfy them, which result in a very, very large distribution the year following our death, which could mean a lot of income tax.
Okay. And just to throw it out there, charity is a great beneficiary of retirement plans.
Yeah, you know, I see this a lot where clients say, well, I want to name, let's say, the Legacy Foundation as a charitable beneficiary, and they'll put it in their trust. And I say, why are you putting in your trust? You got this big IRA. Well, why would I do that? Well, because the trust assets, unless I have more than $11 million,
right,
the trust assets are going to your beneficiaries, your loved ones, tax-free, essentially. Your IRA is not, though. Your IRA has taxable income. That's
right,
when they take their distributions. What if you gave the Legacy Foundation the IRA or some part of the IRA? Well, no one pays any tax on
right,
that.
Right.
So that's a very tax-efficient way
sure,
to conduct your charitable giving at your passing.
Right.
Yeah.
Great. Okay, another question from Shell Point residents. How do I best protect myself and my assets if I become incapacitated during lifetime?
Protected from what?
Well, I guess just to make sure that things are carried on as they have always carried them on.
Yeah. Well, again, I think that speaks to revocable living trusts. You determine the terms of the trust. You determine whether, for example, let's say that I'm supporting one of my children financially and I become disabled. Well, your trust better talk about being able to continue that support during the period of your disability, because otherwise your successor trustee might not have the power to do that. If let's say you're supporting a grandchild going through college, or in some cases, like in my case, I help support my father. He needs some financial help. So if I became disabled, my trust better say that support should continue.
And I would assume that when there's mixed families, that becomes blended families becomes even more of an issue?
Yeah, I mean, just imagine this. So if I'm married, it's a second marriage. She has children, I have children, and I become disabled, and I've been helping support her children. Well, how are my children going to feel if we have continuing distributions to or for the benefit of these other children that are going to eat away at their inheritance?
Right.
So those are really important issues to talk to your estate planning attorney about.
Okay. One of the other things that I'm just going to throw out there is because in my years of working with residents, it's not always the X's and O's and the numbers and the plans. It's the personalities that are involved in the families. I mean, you see that quite often, I assume.
Yes, yeah.
So is there any way to protect yourself? I mean, do you have your clients talk to families beforehand, let them know what's going on, what you've planned and decided, or is it best not to?
That's a great question, and it really depends upon the characters involved in the families and the characteristics. And some of our clients, as you probably have learned, some of them are very closed. They don't like to talk about their finances. It's taboo to talk about those things. Others are quite open with their loved ones. I think it's better to be open and to set expectations. A lot of times kids think that their parents have a lot more money than they really have. The kids might have these expectations of large inheritances, and the parents really need to spend it, on themselves for their own care, for their own enjoyment. And they certainly deserve doing that. And
the longer, the longevity now that that we're living a lot longer.
How many people over 100 years old do we have?
I don't know. We've got a lot here at Shell Point. Over 90. I know we have hundreds of residents.
And I think that's going to continue. As medicine advances, people understand how to eat properly, exercise. So I believe that open communication is a lot better than not sharing.
Sure. Okay, last question from Shell Point residents. We have over 100 new residents here at Shell Point each year, a lot of them coming from out of state. Do they need to update their estate plan?
Yeah, when every state's laws are different, Jeff, as you know, you've been doing this a long time too. Florida's different than most any other states. We do not want, especially if they maintain a residence in their former home state. A lot of our residents, a lot of our clients go up north for the summer. We don't want Massachusetts or Minnesota or Ohio to claim them as taxable residents for income tax purposes, for estate tax purposes, for a state level tax. So one of the things you ought to do is update to Florida law on your documents, indicate you're a Florida resident, and also get your Florida voters identification, Florida driver's licenses, all those sorts of things. But because the laws are so different, and because the taxing authorities need money, the states up north, they need money. So don't open yourself up. And one of the things I look at is, where was the will signed? Where was it signed? Under what laws is it governed by? Good idea to update to Florida law.
Sure. Great. Well, Craig, thank you for being here with us today, answering our Shell Point resident questions. Shell Point, please feel free to give Craig Hirsch a call at 334-1141 if you'd like to set up an appointment to meet with him. Craig also comes out to the office with our Legacy office to do some planning, so feel free to call the Legacy office if you'd like to connect with Craig.